Court does call the case of the People versus Nicholas Chalmers.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Chalmers. Mr. Chalmers, state your name for the record, please.
Nicholas Chalmers.
Your Honor, Mr. Chalmers is before the court for a violation of probation. Mr. Chalmers is non-compliant in that he owes $5. He's made no payment to the court. He failed to report to probation as directed, failed to complete a SPEC class, failed to complete 25 hours of community service, failed to provide proof of employment. He, Your Honor, also has bench warrants out of the 44th District Court, the 36th District Court, and the 39th District Court. He also has a pending criminal case out of Macomb County, a felony burglar tools possession with an alleged date of offense, 20th of 2025. That case, as the court knows, that's a continuation of the same behavior that this case is. Given all the circumstances, probation is asking that the court revoke his probation, sentence him to 90 days in jail, credit for 19 days served, that he served the valence out of that, waive his remaining terms, accept the financial obligations, and discharge him from probation without payment.
Your Honor, I did have a chance to speak with Mr. Chalmers about everything that has been going on. His mother is also here and would like an opportunity to speak to the court if the court is amenable to that. Regarding the terms, I think Mr. Chalmers, I think the one to start off with is reporting to probation. He maintains that he was told he was non-reporting. I spoke with
That he what?
Was non-reporting. I spoke with Miss Pilara, and she indicates that she doesn't have anyone that's non-reporting.
Doesn't happen at this court, so he couldn't have been under that impression.
I explained that to Mr. Chalmers. He understands there was clearly some miscommunication. He regrets that he did not report and is willing to report moving forward.
And I'm going to let you say what you're going to say. But because you've got to represent your client's telling you that. If he's representing to you that somehow or another this court, that he was under some impression that he was non-reporting, or that somehow this could even be characterized as some type of misunderstanding, that's problematic for me because I don't believe any of that. I mean, I'm going to let you say, and I'm not, Ms. Parody, I'm not certainly holding that against you. You have a job to do. But if that's what he's having you represent, I'm not buying it.
Because this was set previously and Mr. Chalmers failed to appear, we've spoken multiple times about this, and he's maintained the entire time that he thought he was non-reporting. And I do believe that was a miscommunication. I hear what the court is saying. Regarding the rest of the terms, it seems to me that he did make efforts to complete everything. So he believes that he did complete that theft class. He reports to me he did complete the community service. He did that at a soup kitchen in Ypsilanti. And he was working for the beginning of his probationary period at FedEx. He lost that job a few months ago, but his mother actually indicated to me that she spoke with FedEx and he can be reinstated to that job if he is released from custody. Mr. Chalmers is also doing some good things, I think. So he is the primary caregiver for his 5-year-old. He lives with his grandmother, who assists with taking care of his son, but he is the primary caregiver. His mother told me today, is a teacher at a middle school in Ann Arbor. And Mr. Chalmers also just got his GED through Washtenaw Community College and is now taking preliminary associate's classes at Wayne Community College. So he does have things that he wants to get out and take care of. He did turn himself in after he failed to appear, so he's not running from this, Your Honor. He wants to show the court that he can complete probation. I would like an opportunity to get Ms. Pilara the proof of completion of the theft class in the community service when Mr. Chalmers can provide that to me. I do think the fact that he turned himself in after he failed to appear is a big indication that he wants to resolve this matter. So given all that, I asked that the court take this into consideration. He was sentenced just back in March, so he does have time to finish up his probationary terms. I tried to look up some more details in the Macomb County case. I couldn't find it in their case search. I don't know if it was user error or what. I just want to see what stage that case is at. I'm not even sure if he's been arraigned on that case. Mr. Chalmers indicated he didn't have an attorney, so I don't have anyone to contact about that as well. So I think that one is in the very, very preliminary stages. So again, I'd ask the court take that into consideration. And then the bench warrants, Mr. Chalmers indicates to me, are mostly traffic stuff. So given all that, again, I'd ask the court to reinstate his probation, let him complete his term. He can pay $300 this week, I think you said, if he were to be released. But again, he has been out of work for a few months. And again, his mother is here and would like to add if the court is open to hearing from her.
Did he make the $200 payment in March?
Ms. Pilara has no payments made. I did not verify if there was any payments made. Do you remember paying $200?
Your Honor, there are no payments made.
That's what I thought as I'm looking at it. And just so you know, he represented to the court on that day, March 11th, that he was going to pay $200 that day.
Yeah, I frankly, Your Honor, I don't remember. I do know, as I stated, Mr. Chalmers was working, had lost work, is the primary caregiver for his child. I don't know if some kind of bill came up or something like that.
And Your Honor, I would also like the court to be aware, it looks like Mr. Chalmers also has a hold at the jail from Wayne County Sheriff for a fleeing bond denied. I don't know if that's an additional. If that's something additional, I don't see the case. I didn't see the case when I ran his criminal history, but I do see he does have that.
For fleeing and eluding.
For fleeing bond denied Wayne County Sheriff.
Judges listen to parents, but sympathy doesn't override patterns. Trauma explains behavior, but it doesn't excuse continued violations. Watch how the court separates who he was from who he's choosing to be now.
He can have a seat there. His mom wants to say something to him. State your name.
Nicole Franklin. I just want to say, he's a great kid. I don't know where all this has come from. He was shot twice and almost died 5 years ago when my grandson was just born. In the chest once and in the stomach once. They tried to rob him for his gym shoes. Ever since then, he's been a different person. We've tried to get help. It was the pandemic time. He needs help. He's a great kid. He's a great father. He's a great father. He takes care of his 5-year-old. Right now, his 5-year-old is born between me and my 78-year-old mother, which is hard. He's asking for daddy every day. Nicholas is really a great kid. Like I said, from the ordeal of him being shot, he just turns into a different person. I just need him home. And I know that's not enough for you from everything you've just heard. Um, we need him whole. I don't know what to say. I don't know.
And you also understand that even if I were to release him today, you won't be going home. Because the last indication from Miss Flora was he's got whatever situation he's found himself in Wayne County, he's got bond denied.
I've been doing everything. I've been checking up on everything. I've called Wayne
Ma'am,
County,
ma'am, ma'am,
and
let me
they were
stop.
putting him on tether.
Let me stop you. Okay. I hear you. I did not think, frankly, in this case that we would end up at this point in time, or at this point. I gave your son every break could coming into sentencing. Didn't make it a very difficult probation for him. And indicated basically that he needed to just get through it. If he represented to me on the date of the sentencing and I just went through it that he was going to pay $200 in. And it really isn't so much about the money, it's about the representation it makes to the court that he's going to do this. And I'm now here, whatever many months later, and he's paid nothing and didn't go to probation to tell probation if he had had a problem. We run into that all the time. He just had to say, I can't make this. This is what I can do right now. And he didn't do it because he wasn't going to probation. I can tell you right now, and I hesitate in doing it, but when he's telling me he thought he had non-reporting probation, if Miss Polera pulls up his probation order, it's not going to say that. And I know it's not going to say that. And that's why I stopped Miss Parody when she was saying, because it's not true. I don't have those. Not in that way. And he knows that. And he's just, ma'am, it is hard for me to sit here and to try to tell a mother.
This isn't about jail time anymore. This is about accountability. When a judge says a defendant is disrespecting his mother, that's moral condemnation, not legal analysis. At this point, probation is already dead. The sentence is just paperwork catching up to reality.
That he isn't acting and he isn't what you raised. Right?
He's not. He's not. I didn't raise him like that.
I know you didn't. I can tell by the way that I can tell you did not raise him this way. And the problem is, he's going to have to make the decision to change his behavior. You can't do that for him. I don't know you, but I'm sure throughout his life, you have done everything within your power to give him what chances, what opportunities there are. And all he had to do was to grab onto those opportunities, pull himself up and just do the right thing. And throughout everything, he's not doing that. It also troubles me outside of all of that, that the warrant that he's got out of Macomb County is, he's here basically on a breaking and entering charge. And the warrant that he has out of Macomb County, the felony warrant, is possession of burglary tools. He's just involved in the same activities over and over again. Ma'am, far be it from me to try to tell a mother about her child. Because And I think you know what I mean, but I don't do that. But I'm telling you, he's lying to you. And most importantly, what angers me, particularly after hearing from you, is that the way that he's operating his life, he's disrespecting you and your mother, his grandmother. And there's a lot in life I'll tolerate, but I'm gonna tell you what, and people know this. You come in here, you disrespect your mother. If they're not gonna do something, I'm sure as heck you don't want to be before me doing that, but he's disrespecting you in every way that he can because he thinks he knows more. Was there anything else you wanted to tell me?
His son needs him. He needs him. His son needs him. He needs him.
Thank you, ma'am.
Thank you. I love you. Love you. Love you.
Anything else you'd like to say, Miss Barron?
Nothing from me, Your Honor. I do appreciate Ms. Franklin speaking to me and speaking to Your Honor and on behalf of Mr. Chalmers. I do think he has a very good support system.
Chalmers, is there anything you want to tell us?
There's nothing I would
before
like to say.
close sentence?
No, Your Honor.
I don't know how you do that to that woman. I honestly don't understand it. I don't understand how, if you don't have enough respect for yourself, how you couldn't have enough respect for her not to do this. For God's sakes, that's your mother. Who I don't have a doubt in my mind that if it came down to it, would lay down her life for yours. And all she does is, here's all the things that you've done or not done that you're supposed to do. Still has the courage to come before the court and beg for mercy for her son. I'm going to waive all remaining terms except for his financial obligations, discharge him from probation without improvement. You've got certainly bigger fish to fry in other counties, it looks like. I'm going to order 93 days in jail, give you credit for 19 days served. The balance the defendant will serve. Defendant is remanded. Court does call the case of the people versus Dominique Kelly Payne. Kelly.
The public defender Natalie Pate and on behalf of, is it pro? Record, sir?
Dominic Kelly Payne.
Thank you, Your Honor. This is matters set for show cause. There is still a balance. My client is currently held on other matters. It states to me that he is set to be released to treatment next week, but he's not sure exactly where he'll be released to or what treatment facility.
It's probably a 30-day or.
I don't have
Maybe
that information.
Longer.
It might be.
Pardon?
Might be longer.
Might be longer, might be a 90. Give me my February date.
Thank you, Your Honor.
Yes.
During the matter of February 4th, 2025, 9 a.m. 2026, 9 a.m. Thank you.
Your Honor. Thank you, sir.
Court calls the case of the people of Ibrahim.
Your Honor, this is a show cause for failing to pay fines and costs. Because of counsel.
Does not have counsel.
I am trying to-
What do we have as a balance? No, I got it. Okay. Sir, state your name.
Ibrahim.
All right. Mr. Ibrahim, you're not, this is a show cause. You're not represented by counsel. Did you want to be represented by counsel?
Yes, please.
I'm not sure how this,
I mean, is it necessary? You said it's a show cause just for non-payment. I'm in prison now. I don't have.
right, it's a show
the
cause for
means.
non-payment, but I will give you counsel just in case. But, so this is a public defender case, if you can step in. I would indicate that Mr. Elman, I think, represented Mr. Ibrahim at the previous one, but I cannot tell whether that was because of a conflict or whatever, but.
I would, sorry, Assistant Public Defender Natalie Pate with on behalf of Mr. Ibrahim. Your Honor, I don't have the balance right now that Mr. Ibrahim would owe, but I do know, because I represent him on another case, that he was just transferred to MDOC on October 31st from the Washtenaw County Jail. So I believe it is anticipated he will be there for some time. I would ask for at this time an adjournment of the shown cause.
How much do you have him? I have him with 410.
That is correct.
410. Mr. Ibrahim, have you been sentenced to MDOC time?
Correct.
All right. What is your sentence?
23 months with credit of 15. So I should be out June of 26.
Got it. And this is okay. So this is a trespassing case
I am sure.
So
with a 30-day maximum on it. And the only reason the fines and costs are where they are is because he didn't pay them back in 2021 because he was busy with other stuff. No, I'm just messing with you.
so I've been arraigned on this. I've been arraigned and I already pled on this, or I thought this was a new
Yeah,
charge.
you pled on it back in on January 20th of 2021. You
That's
pled
when
on it.
happened.
No, it happened April 8th of 2019.
Yeah, I wanted to go
And
to
then-
trial on this. I wanted to go to
Pardon?
trial on this case. I wanted to go to trial on this case. I never meant to plead on this case or anything like that.
Well, you did though.
Did I withdraw
And
my
so
plea?
you want them to file a motion to set aside on a trespassing?
Yes, because I mean, I paid for the ticket. I was there at the movie theater. It was a whole incident.
Paid for
And
what ticket?
Mr. Ibrahim, I
It was
wouldn't talk about the
Yeah, I wouldn't
case.
talk about the case. I mean, if he's gonna file a motion that says, I was gonna tell you what I was gonna do.
Yes, you're-
It's what I was gonna do was just waive everything except the state minimums and just close it. But if he wants to adjourn it out to motion to set it aside, I don't know that I can do that after 4 years, but I'll give you a shot at doing it.
in that case, Your
here-
Honor, Mr. Ibrahim, go ahead.
No, go ahead.
In that case, Your Honor, if Mr. Ibrahim is wanting to proceed in that fashion, I believe our office may withdrew because of a conflict, and if that is what he wants to do
Right,
moving
because
forward.
but I don't know who's gonna, he wants to. Well, doesn't make much
Exercise my
sense to me,
rights.
and I don't know that I can do it anyway, but here's what I'll do. I'll adjourn this out. Give me a date,
December.
February.
What about the two driving license suspended? Am I gonna be seen on that today as well?
No,
I-
Mr. Ibrahim.
I don't have those in front of me, sir. February 4th. During this matter, February 4th, 2026, 9 a.m. Continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Diana Seaborn.
The tone of the courtroom changes instantly here. Cases involving children, especially special needs children, trigger the highest duty of care under the law. Bad day defenses don't survive this context. The judge isn't just sentencing conduct, he's protecting trust.
Good morning, Judge Simpson. Attorney Carl Jordan, P 57226, appearing on behalf of Ms. Deanna Seaborn, and Ms. Seaborn is present, Your Honor.
All right, go ahead.
First of all, Your Honor, I apologize for running late. I know that the time was changed, but I was in another court. No excuses. I apologize.
Very good.
Your Honor, with respect to Ms. Seaborn, she did plead no. I did go over the PSI with her. There are no additions, deletions, or corrections made. I would just like to address what I believe would be an appropriate sentence.
Yeah, go ahead.
They are asking, Your Honor, for 29 days, 365, and I believe that they're asking for that to be held in abeyance, but that you serve 29 days. I don't believe, Your Honor, that that would be appropriate. And I'm jumping straight to that aspect because, first of all, Ms. Seaborn is extremely remorseful for what happened. She did not give a statement because she was allowed to plead no contest due to civil liability. But make no mistake about it, she took her job seriously. She did not want to harm anyone, certainly not a special needs child. This is by no means an excuse, Your Honor. But when I asked her, why she may have done what she did, because she has no prior record, she said, being spat upon at that point, she just kind of lost it. But again, I am by no means saying that that is an excuse, Your Honor, especially when you consider it as a child, and especially when you consider it as a special needs child. But I do want the court to know that had that not occurred, she would not be before any criminal judge, and I do not believe that she will be in front of any criminal judge in the future. She will complete probation successfully and go on and live her life. There have been some consequences. She did lose her job that she had as a result of these charges. So now she is doing DoorDash in addition to taking care of her sister. But again, she's sorry, she's remorseful, and she wants the court to know she has learned her lesson. Thank you, Your Honor.
Anything you want to say before I impose sentence?
No.
Well, I'm going to say this, counsel, and I appreciate the elocution. However, when I look at the circumstances of this case, this is a special needs child. Certainly some things are going to occur. Certainly it could maybe raise one's ire, but to do these things is, in my estimation, inexcusable. I mean, these parents, through each stage of a process on a day-to-day basis, entrust their child to these folks. And quite frankly, when you violate that trust, it's inexcusable in a lot of ways, in my mind. I mean, in particular, that this is a child that really cannot defend themselves if they even comprehend exactly what's happening to them. I mean, which just has to be sort of the worst thing. Was there a victim's impact statement? I was expecting that there might.
I did not receive one, and I do not see the victims present.
All right. It is a sentence of the court. Place you on probation for a period of 60 months. You're to pay $655 fines and court costs, $1,800 probation oversight fees. When can that be paid?
You said 1,800, Your Honor?
Yes. That's what I have. Yeah, it's 60 months.
Your Honor, she realistically says that she can pay $150 a month.
$150 a month. That will begin in January 2026.
Thank you, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the anger habits program. You're to complete 50 hours of community service. There's to be no contact with Elizabeth, Peter, or Eli Lorensky, if I'm pronouncing that last name correctly, that is directly or indirectly. You are not to be working with and or around any minor children. There's to be no assaultive, threatening, or intimidating behavior by you. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to maintain employment with verification to probation. And let me just say this. Like I said, these parents entrust you. And, at no point, other than for the purposes of safety or other legitimate reasons, do you have the right to place your hands on that child? That's the only basis of you're trained, should have been trained, and I think you were, as to how to deal with these circumstances and these situations. You're having a bad day, losing control, and doing this kind of thing is never an option. And I understand counsel isn't saying it is an excuse, but it's not an option for you when you get into that role and in that circumstance. And so what I'm going to do is I'm going to order 365 days in jail. Give you credit for the 1 day that you serve. You will be remanded to serve an additional 29 days, and then the balance will be suspended. Defendant is remanded.
Your Honor, I spoke to my client about this, and she said, could she have time to get her affairs in order? And I said, well, really, what affairs do you need to get in order? I mean, the President of the United States could get his affairs in order probably quickly. And she said, I do have a daughter who's 14, and I wasn't expecting to have to serve any time because it wasn't part of the negotiations. May she have at least a few days so that she can arrange for a 14-year-old to go somewhere? She does have a sister, but her sister is a person that she takes care of. Her sister was shot. She's in the courtroom. So she truly does need to make provisions with respect to her daughter. And she understands if she...
At the moment this was happening with the child, was that child permitted to make any arrangements for their care? Probably not.
Of course not.
I will not pay her the same courtesy. Defendant remanded. She'll go today.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Lucille Slater.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Slater, who is approaching. Please state your name for the record, ma'am.
Lucille Slater.
Thank you.
Thank you, Your Honor. Today is the date and time set for sentencing. I have had the opportunity to review the PSIR with Ms. Slater. We only have one brief correction, and that is on page 2 under the summary. It states that she pled no contest to this charge on the date of her pretrial hearing on the 17th. That is correct that it occurred on the 17th, but that was the date of her final settlement conference. That is the only correction we have, Your Honor. And as to the recommendation, I do believe it to be fair recommendation, and I would ultimately ask the court to adopt it. Ms. Slater presents to the court, she's 76 years old with no prior convictions of any kind. This is quite literally her first rodeo in this situation. She has, throughout my representation of her, taken this matter very seriously and has, to me, shown a lot of remorse for her actions on that day. She, prior to this incident, she had worked at this position for almost 7 years, and to my knowledge, had no other prior incidents of this kind. This is her first interaction with the criminal justice system. She has expressed much remorse to me. To my understanding, she has complied with her bond to the T and has appeared in person for all her court dates. I would ask that the court adopt this recommendation.
Ma'am, is there anything you want to say before the court imposes sentence?
No.
Your Honor, I'm sorry to interrupt.
Yes, I will get to that in just a moment. I was aware.
No, Your Honor.
All right. You guys are gonna need to have a seat here. All right. Because somebody. I'm sorry. I understand there's a victim's impact statement.
Yes, Your Honor. The minor child's mother and father is Julie and Ryan Franks. They are
Julie and Ryan.
Julie and Ryan.
Got it. All right. Hello.
Hi, Your Honor.
Could you state your names for the record?
Yeah, Julie Franks.
Ryan Franks.
All right, thank you. And I'll need you to take your hands out of your pockets if you would. Thank you. All right, I think we're all set now. Go ahead.
Thank you, Your Honor. Thank you for giving us the opportunity to speak today. We are here as the parents of a 7-year-old little girl who was physically grabbed and yelled at by Miss Slater at school, a place where she should have felt completely safe. That day changed our daughter. Since then, Natalie has struggled with anxiety and fear. She often asks questions no child should have to ask. Things like, why did that happen? And will that happen to me again? It has been incredibly painful as her parents to watch her confidence fade and to see her question the trust she used to have in the adults around her. We spent months trying to rebuild her sense of safety through reassurance, through love, but this incident left a mark. It's something she carries and will carry with her forever, and something we, as her parents, will never forget. What's been equally hard is seeing how little remorse Miss Slater has shown. When police reached out to get her statement, she hung up on them and blocked their number. That forced us to move forward and press charges. When officers went to her home, she refused to answer the door, even though they could clearly hear people inside. Those actions speak volumes. They show a complete lack of accountability, of remorse, and of understanding of the harm she caused. We truly believe that if given the opportunity, she could have hurt another child. We understand that everyone makes mistakes, but when an adult's action causes emotional and physical harm to a child, that can't be taken lightly. Our greatest hope is that the court ensures that this individual is not in a position to work or be responsible for children. No family should have to go through what ours has. We're speaking today, not just for our daughter, but for every child who deserves to feel safe and protected at school. That's all any parents want, to know that their child is safe when they walk through those doors. Thank you, Your Honor, for listening to our story and for considering the impact this has had on our daughter and our family.
Thank you for coming down. All right. Yeah. Is there anything she wants to say now?
Just very briefly, Your Honor, I do want to mention Ms. Slater has taken accountability and has expressed remorse in this matter. Of course, to me, and of course, by entering a plea in this case. She takes accountability for what actions did occur, and she is remorseful. I can say that through my many discussions with Ms. Slater, and she does take accountability for what did occur. And I do believe she is remorseful, and her choice not to give a voluntary statement to the police, I believe, was based on the advice she had received through counsel and other means. That being said, she is remorseful for her actions and has taken accountability.
Ma'am, anything you want to say?
No, Your Honor.
Okay. So I get the notion that prior to anything happening, and I can understand why it might confuse the Franks, or they're not appreciating that she may have been told by she was a union employee or through lawyers not to say anything, not to have contact. So I get that, and that might be, one might expect as a parent that somebody might act a little bit differently. But I get why somebody would act. I am, however, a bit concerned that as we get here today, as we are here today, that there's this little girl and something happened to her. And standing there in her stead are her parents who have taken their time to come down.
This is one of the most powerful moments in the entire docket. The judge isn't punishing words, he's punishing the absence of them. In courtroom psychology, remorse isn't just what you feel, it's what you demonstrate when it matters most. Silence here speaks louder than any apology ever could.
To let the court know basically the effect that this has had on their child, which I guess spoken like true parents, but also moms will do this. They don't express necessarily the impact that it's had on them, but they talk about what's happened to their child. And I did something different because I was told prior to this hearing and in reading the report that there wasn't a sense of remorse for what had happened. Even if done accidental, even if done out of a misapplied sense of how to have this child saved. They were people saying, well, she's not really showing remorse. She didn't really care what happened to this child. And where I did something different because my staff here knows how I typically will handle these situations when I have impact statements. You would have sat down. They would have spoken to me, and then you would come back up. But I would not have addressed you prior to Frank speaking. Do it that way pretty much every time. I did it differently for a reason today. Because I was at least going to give you maybe 2 opportunities to look that little girl's parents in the eyes. And whether or not you meant to do what you did, just to tell them you're sorry. Because that's their baby girl. And I gave you those 2 opportunities the first time. Nothing. You sat down. You heard Mom speak. Came back up. Asked you again. And nothing. I don't know how you do that. It puts into perspective for this court what happened that day. Because I sat there and I thought to myself, well, here's somebody who works for the school. Things can get out of control. They can do this, but it's just like I told the person before you. I'm not sure that you've got a right, except for the purpose for safety reasons or other necessary reasons, to put your hands on somebody else's child. You can't do it. And then if you lose your mind for a minute, for whatever the reason, and you do, then quite frankly, you take responsibility for it. You say, I shouldn't have done it. And if you can't apologize to the little person, you apologize to her parents. So at least her parents can go and say, hey, look, she apologized. This is her version of it. She didn't mean it. And they can sort of move forward with that lesson that they're entrusted to teach their child. But you can't even do that.
If I may, Your Honor, my client and I have had to discuss the no contact order multiple times, partially for that reason. I have had to remind her that she is under a court order not to reach out to the Franks and apologize, not just the minor child, but as the adults. And pursuant to that court order, she has not had any contact with them whatsoever, good, bad, or indifferent. And she is sorry to the Franks.
But today, Miss Pate, that's what I'm talking about. I get everything maybe before they got here today. But for God's sakes, there are parents here that are talking about what trauma has happened to their child at your client's hands. And she didn't even have to look at her. She could have told me, as people do, that she's sorry, but nothing.
But I am sorry, sir. And Your Honor, I would like to reiterate, and not to speak out of turn, Ms. Slater is very nervous about being in front of Your Honor and in this court today. And I do reiterate that she is 76 years old and this is her first time coming to court, to my knowledge, for anything, but I know for a fact for something like this. She has expressed her remorse to me multiple times. I've had to remind her of the no contact order for that purpose. And I do understand what the court is saying and her not saying anything today. However, I can represent to the court that she has expressed remorse to me about this incident. And she has wished she could apologize privately, but
Okay.
for the no contact.
That's all fine and dandy. But how do they know that to say that to their little girl? They don't.
It's unfortunately one of those situations with our, our system, which of course there's a very much a need for no
This
contact.
is not, no, today, I get beforehand. But today, I gave her 2 opportunities. She doesn't have to even look at him to just say she's sorry, and she didn't.
She did, Your Honor. Right. I just want to make sure the court heard. I'm sorry. She said it a little quiet.
Oh, I heard it. Too late. Is that said, because at this point, I don't know if that's said because she's really sorry and remorseful about what's happened to this little girl, or if she's only saying that because I pointed out that she didn't.
Your Honor, what I can say is before today, she's expressed remorse to me. And as Your Honor knows, I do represent a lot of clients, and quite candidly, there are a lot of clients who don't. And unfortunately, I don't have the opportunity to say that about them. But in Ms. Slater's case, I can say that. We've had several meetings outside of court as well, in person in my office, both to discuss this case. And quite candidly, since the beginning, Ms. Slater has both been apologetic, but also wanted to take accountability. I believe one of her words to me, our in-person meeting when we were reviewing the footage of the incident in my office, was, I believe I deserve some sort of punishment, and I want to be sorry and move this behind me, and I know I can't reach out to the parents. And of course, at that time, I reiterated, no, absolutely not. Do not reach out to the parents. You're under the no contact order.
I have to get the Frank's credit, because I think that had been my daughter, I would have lost my darn mind. I'm not even going to pretend I would do something different than that. But that's me. It's a sentence of the court. I'm going to place you on 18 months prosecuted deferred sentence. And I'm going to let you know that in my mind that I wasn't sure whether or not I was even going to allow the deferred. I looked at your lack of record and decided that I would indeed give that to you. But initially, my first thought was I wasn't going to give you the benefit of even being part of that program. But I will place you on that program for a period of 18 months. $455 fines and costs, $540 probation oversight fees. When can that be paid?
Your Honor, my client says she can pay $200 today and is asking for a payment plan as to the rest.
How much can she pay per month? Well, no, I'm going to make it $200. She's to pay by December 22nd, 2025, and then a payment plan as arranged by probation. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an anger management program as directed by probation. I am ordering no contact with Julie, Ryan, Natalie Franks directly or indirect. I'm ordering that there be no working with and or around any minor children. There is to be no assaultive, threatening, or intimidating behavior. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I will set a review hearing on this case that is to be held May 12th, 2027 at 9 a.m. With reference to jail time, ma'am, I have taken into account who you are and what I could see on this paper. I've taken into account the things that I've said on the record. And I've taken into account, as I did with the deferred sentence, the fact that a lack of record for your entire life, at least as we see it here. But you can't grab someone's child. You just can't.
Understood.
So it's 90 days in Washtenaw County Jail. Defendant is to serve 15 days. The balance of that time will be suspended. Defendant is remanded.
Your Honor, I know Your Honor has issued a ruling, but may I make a request that her to be able to turn herself in a few days? Her husband does have some severe health issues, and I'm just asking, given.
I need medical regarding that, and I will consider it, but right now she's going. Okay.
Hi.
I'm sorry.
Miss Sal.
Stop, okay. I'm sorry. I can't stop. A little bit better learned hearing on behalf of Miss Sal. Miss Sal, state your name for record, please.
Myra Sal.
Oh, yeah. Now, we did review this case in court. We don't have any deletions. We do ask that you adopt probation's recommendation regarding the fines and costs. Ms. Sal has been through a tough period of life as reflected in the investigators' summary. She was homeless when this case arose. She recently got back into work. She completed school. However, she just lost her job because her car broke down, I believe. Whatever happened, she didn't have transportation to work. She lost her job. So now she's out of work again. Ms. Sal has been really putting a lot of effort to get things on track. So I am asking that the court take that into consideration and give her some time to pay that. She told me today she's gonna work something out, but we'll definitely need some time.
Charles, anything you want to say?
Hi everyone. So this situation is just, I hate that I have to go through it or am going through it, but just please allow me some time to pay my balance. And thank you. I don't know if I should say thank you, but thank you for helping. I don't know. And hopefully you never ever see me again, because this is not how my life is. This is not, yeah, I don't. But thank you, Your Honor.
All right. It's a sentence of the court, 6 months probationary term. I'll order $400 fines and costs, $180 probation oversight fees. Ma'am, you went back to school?
Yes, yes, sir, I did. Yes, Your Honor.
And what did you get your degree in? Or what did
I'm
you
a
decide to be when you grow up?
It just took me about 30 years to figure that out. I'm a massage
Okay.
therapist. I'm a massage therapist.
Okay. So you went back to school. All right.
Yes, sir.
Fantastic. All right. So what I'm going to do is I'll order the $400 fines, $180 probation oversight fees. That is to be paid as arranged by probation. So when you get yourself employed, just keep in touch with us, Valera, and try to make sure that you're on a payment plan that you could do. Okay.
Yes, sir. Thank you so much, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation.
Okay.
You are to complete a gun safety class as directed by probation. You're not to possess any weapon, firearm, ammunition, or anything fashioned to be a weapon. I will order a forfeiture of the weapon as indicated in the file to 9mm. I will order 90 days in jail, credit 2 days. The balance is suspended. All right?
Thank you.
Thank you, ma'am. Thank you. You take care.
You as well. Have a great day, guys.
All righty. Court calls case of the people versus Middleton. you weren't going to catch me this time. State your name, please.
Taquangela Middleton.
That's exactly what I was going to say. All right. Where is this a show cause combined to cost? Okay. I don't have probation review.
I'm sorry, what was that?
Miss
No,
Middleton.
money.
No. Hold on a second. I think it's because of her fines and costs. She hasn't paid.
Yes, it's just. You are. So she has no counsel.
All right. You haven't paid. You're here on a show cause failure to pay fines and costs, Miss Middleton. Did you want to be represented by an attorney?
I mean, if I could just talk to you, I mean, I don't know. I'm
You
just
can talk
trying
to me.
Okay, so look, I'm just tell you, be honest. I'm broke. I have other obligations, and I thought I can handle it, and it's just very hard. I mean, I could try my best. I'm gonna do my best. Every month I can do like 25. If you can extend the
When
date
can
for
you
me to
start
pay
that?
it.
When can you start that?
December.
December?
Yes.
You're gonna $25 a month.
Yes.
You sure?
Yes.
Where'd you get that first name?
Oh, I was born and raised in Georgia, so it's like country.
Wow. you just lambasted the whole state, didn't you?
Yes. It's, oh my God.
It's
Down
all right.
here.
All right. What I'll indicate, defendant to pay $25 per month. Do we have? All right. And that's to begin in December.
Okay.
And then I'll adjourn this hearing out to, is it going to be March 4th or 5th? Is it a leap year?
March 11th.
Oh, of course. So I'll adjourn this to March 11th, 2026, 9
Can
a.m.
it please be Zoom?
You have to fill the paperwork out.
Oh, I mean, okay.
Wow, really?
I'm so sorry. I'm
Really?
sorry. I'm
I
sorry.
just said you need to fill the paper. That's
Okay, I'm sorry. You're right.
is why'd you do that?
I
That's
know I was thinking it and then it's just
yeah, I know it just came out.
it can't I
That's a
apologize.
Georgia thing.
Yeah. Yes, for sure.
Don't even try to blame. Don't be blaming it on that state. That's all you. Just get those payments in.
All right, thank you.
Thank you.
Bye.
Court calls case People versus Jeremiah Sawyer.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Sawyer. Mr. Sawyer, state your name for the record, please.
Jeremiah Sawyer.
Your Honor, we reviewed the pre-sentence report, don't have any changes, additions, or deletions. We ask that you adopt the recommendation. Mr. Sawyer's been in custody, I think, for 264 days as of today.
Pardon?
He's been in custody for 264 days as of today.
Does he have an anticipated release date or no?
An ex-jail, well,
I
maybe,
go to court and go to trial in 9 days.
oh, right, the 21st.
Yeah.
Anything you want to tell me before I impose sentence, sir?
No, sir. I apologize for the door, but I do want to say I do think that the door was I think I was the one that, exposed the fragileness of the door. I don't feel like the sole cause of that door breaking. I kicked the door like 4 times. I'm pretty skinny. I don't think I'm that strong, right? But the door broke open. I take responsibility for it, but it's like they changed all the doors over there after that. So I think I did them a favor and exposed the door
gotta be
there.
kidding me.
Oh,
Are you did a favor? Okay. No, go ahead. You're allowed to say what you want to say.
no, I just feel like
No, go for it.
that the doors was, you feel me? It wasn't me who basically it was gonna happen regardless, and they end up changing all the doors after that. So it's not like I just kicked a brand new door open. These doors are like 70 years old, man. So, y'all,
We're clear. These are doors at the jail.
yeah,
Yeah.
in the hole.
Yeah.
Yes, sir. That's all I'm saying, they charged me $6,000. I feel like that $6,000 they charged me is like me paying for every door in there. Like,
They are thick doors.
So as a citizen of Washington, I should be thanking you? Is that what you're telling me?
I'm not saying
Is that no? You telling me I ought to be thanking you for exposing something that needed to happen
I'm just saying,
so that we did it?
what if a more aggressive person kicked that door open? And they wouldn't know that the door was that weak, right? And then something happened and then somebody got hurt behind it.
So you're saving us all.
You never know. God working mysterious ways. That's all I'm saying.
Okay. You done?
Yeah.
Okay. Let's see. My turn now. $125 statutory fees. Yeah. Savior of the Washington County Jail. You're also going to owe $5,791 restitution to the Washington County Jail payable through the court. I'll order 93 days in jail credit, 93